Hi, welcome back and good day to everyone. This is attorney Lyndon Masterin. I'm a coach, moderator, and instructor for this course, the, the law on partnerships and corporations. Now we are in Title 3 of the Corporation Code. So we'll proceed with our discussion. This is already Part 7 of installment. This is the Part 7 installment of this course. And we begin our discussion with Section 22, the Board of Directors. This is for stock corporation, while the Board of Trustees for non-stock corporation. Okay, what is the role of Board of Directors or the Board of Trustees? So the board shall exercise the corporate powers, and they are responsible in conducting all business and control all the properties of the corporation. And to be a member of the board of director or trustees, the qualifications are: number one, majority of them should be residents of the Philippines. Secondly, there should be no disqualification, or they should not be disqualified by law, meaning they should be of legal age and legally capacitated. And third, for a period of at least 5 years before being elected or appointed, he must not be convicted of a crime involving moral turpitude or suffer from civil interdiction. This is penalty of imprisonment more than 6 years, or has violated the Corporation Code or the Securities Regulation Code, which is Republic Act 8799, or found administratively liable for any fraudulent act, even if judgment was made by a foreign court or equivalent foreign regulatory authority for similar acts, violations, or misconduct. And fourth, the director or trustee must own at least, the director must own at least one share of stock. So this is for stock corporations, or a member of the non-stock corporation. So the term of directors would be 1 year, while those of trustees, they shall be elected for a term not exceeding 3 years. So there's a new development about independent director now. According to the new corporation code, independent director is a person who, apart from shareholdings and fees received from any business or either other relationship which could reasonably be received to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. So an independent director is necessary to be elected for corporations which are vested with public interest. Corporations vested with public interest are those which are here in letter A, those whose securities are registered with the commission. Corporations listed with an exchange or with assets of at least 50 million pesos and having 200 or more holders of shares, each holding at least 100 shares of a class of its equity shares. So if it's 250 million divided by 200, so that would be at least 500. No, 250. 250 to that, okay. Other corporations vested with public interest are banks, and quasi-banks, the NSSLAs for the non, uh, uh, this was discussed in the previous uh, title. This is Savings Loan Associations, NSSLAs, Unstock Savings Loan Associations. Yeah. So these are cooperatives. Then we have pawn shops and corporations engaged in money service business, pre-need, trust and insurance companies, and other financial intermediaries. And other corporations engaged in businesses vested with public interest similar to the above. So in this kind of corporations, it is required that at least the board member must have independent directors. And these independent directors should constitute at least 20% of the board. So if there are 5 members of the board, so 20% of that is equivalent to 1, you know, 1 member. So if there are 10, so at least 2 of the board members should be independent directors. Okay. So how are directors elected? So there are different methods in electing directors in a stock corporation. The first one is by straight voting. So straight voting. So every stockholder may vote such number of shares for as many persons as there are directors to be elected. So if there are 5 members in the board to be elected, then you have 1 share. So the number of votes you have will be 5, no? Because there are 5 directors multiplied by 1 share, that would be equivalent to 5. So you have 5 votes. So straight voting means that you will give 1 share, 1 vote for every 1 candidate. And for a total of 5 candidates. That's straight voting. So if you have 5 shares, how many votes can you cast or you're allowed to vote? So 5 times 5 would be 25 votes. So for straight voting, you would cast 5 votes for each candidate and not more than 5 candidates. Okay? That is straight voting. Another method is a cumulative voting for 1 candidate. So this happens when a stockholder is allowed to concentrate all his votes and give 1 candidate as many votes as the number of directors to be elected, then multiplied by the number of shares that he has. No? So again, if I have 5 shares of stocks and there are 5 directors to be elected, so I am qualified to vote 25, to cast 25 times, 25 votes. So in cumulative voting, I would only give all my votes of 25 votes to 1 candidate. So that is cumulative voting for 1 candidate. Another method would be cumulative voting by distribution. So here the stockholder may accumulate his shares by multiplying also the number of his shares by the number of directors to be elected and distribute the same among as many as he shall see fit. So if he has 25 votes, because 5 votes times 5 candidates or 5 members to be elected, or 5 directors to be elected. So he can accumulate that vote by distribution. So let's say 10 votes to Mr. A and another 15 votes to Mr. B, okay? So that is cumulative voting by distribution. So he's not voting only for one candidate, but this time for as many candidates as he sees fit. So it could be 2, could be 3, could be 4. No? Okay. Another way of method would be voting in absentia. So a stockholder may participate in casting his votes either in 1, 2, 3 and through remote communication or in absentia. So remote communication is by way of Skype. You know? So the new corporation code has already adopted the new technology, which is brought by internet. You know? So if the election is accessible through Skype, then a stockholder may cast his votes and or be counted as present for purposes of reaching the quorum through Skype or through Teams or Zoom. No? So voting in absentia. Okay. For non-stock corporations, members in non-stock corporation may cast as many votes as there are trustees to be elected, but not cast more than 1 vote for 1 candidate. So meaning they're only allowed to use straight voting. No? Only straight voting. So if there are 7 members to be elected in the board, so a member may cast 1 vote for 7 candidates. So he has entitled for 7 votes, but he cannot accumulate more than 1 vote for 1 candidate. So this is straight voting. Only straight voting for non-stock corporations. In conducting elections, the corporations are required by law to reach a quorum. So there must be a quorum achieved by the presence of proxy. So quorum is the number, such as a majority of officers or members of a body that when duly assembled is legally competent to transact business. So that is the definition of a quorum. Okay. Then secondly, the voting must be by ballot. So if you have casted, if you have voted in the last political election, it is by way of ballot, no? Secret balloting. So because there is another way of election which is by oral or saying, yes, I vote, raising your hand. Okay. So this, the required conduct of election of board of directors or trustees is only by ballot. Then if there is no election held by the corporation because there is no quorum or not a majority of the members were present, so such meeting may be adjourned and reported to the commission within 30 days from the date of the scheduled election. The report shall specify a new date for the election, which shall not be later than 60 days from the scheduled date. On the other hand, there are shares of stocks which are limited, or there are limitations on the right to vote. So firstly, where the Articles of Incorporation provides for classification of shares pursuant to Section 6, non-voting shares are not entitled to vote, except as otherwise provided in Section 6. So we already discussed this. The redeemable and preferred shares are allowed to vote on specific transactions or specific developments of the corporation. An example would be amending the articles or extending the life or the term of the corporation. So it's found in Section 6 of the Corporation Code. Secondly, preferred or redeemable shares may be deprived of the vote, of the right to vote, unless otherwise provided. Of course, fractional shares of stock cannot be voted, and they cannot vote also, unless they constitute at least one full share. Treasury shares have no voting rights. So these are shares which have been issued by the corporation and reacquired by the issuing corporation, as long as they remain in the treasury. Fifth, holders of stock declared delinquent by the board for unpaid subscription cannot be voted or cannot vote during elections. Number 6, a transferee of stock, if his stocks transfer is not registered in the stock and transfer book of the corporation, so he is prohibited from voting. And lastly, a stockholder who mortgages or pledges his shares and gives authority for a creditor to vote will be allowed. Now let's go to voting trust agreements. So this happens when one or more than one stockholders of a stock corporation may create a voting trust for the purpose of conferring upon a trustee or trustees the right to vote, and to others other rights pertaining to the shares for a period not exceeding 5 years at any one time. So meaning if you are a shareholder and you enter into a voting trust agreement, so you will not vote, but the trustee will vote for you. And the right given would not exceed 5 years. However, if the voting trust was a requirement for a loan agreement, the period may exceed 5 years, but shall automatically expire upon full payment of the loan. So this pertains to shares of stocks which has been mortgaged, and there is an agreement that the mortgagee or the one who's lending the money may cast or is allowed to vote during elections. So this is called voting trust. And in this scenario, the period may exceed 5 years for as long as the loan is not yet paid. But once the loan is paid, then the voting trust will automatically expire. Okay, let's go to section 24, corporate officers. So immediately after the election of the board of directors, the directors must formally organize and elect the different set of officers. No? The president, who must be a director. They should elect the treasurer, who must be a resident of the Philippines, a secretary of the board, who must be a citizen and a resident of the Philippines, and such other officers as may be provided in the bylaws. And if the corporation is vested with public interest, like banks, quasi-banks, so on and so forth, the board shall also elect a compliance officer. So compliance officer is a person who is responsible in complying with the laws, specifically the corporation code. No? So the same person as directors may hold, or the same person as officer may hold 2 or more positions concurrently. So he may be a president or a president, and at the same time he is the compliance officer. Okay, or he may be a treasurer and secretary at the same time. Okay, but except these positions where it cannot be concurrently be occupied by one person, and that is the president and the secretary, or the president and treasurer at the same time. So the president should not be a secretary at the same time, or a president and a treasurer at the same time. Now the officers shall manage the corporation and perform such duties as may be provided in the bylaws and or as resolved by the board of directors. Okay, section 25, report of election of directors, trustees, and officers. So, or non-holding of election and cessation from office. So within 30 days after the election of directors, trustees, and officers of the corporation, the secretary or any other officer of the corporation shall submit to the commission meaning the SEC, the names, the nationalities, the shareholdings and residence addresses of the directors, trustees, and officers elected. Non-holding, we already discussed that in the previous slide, which is this one here. Non-holding, report of no election. So report of no election should be made 30 days from the date of scheduled election, and there should be another date for the election. Okay, let's go to some principles, and the first one would be the business judgment rule. In the case of Philippine Stock Exchange versus Court of Appeals, decided in 1977, the Supreme Court ruled that questions of policy or management are left solely to the honest decision of officers and directors of a corporation, and the courts are without authority to substitute their judgment for the judgment or the judgment of the board of directors. The board is the business manager of the corporation, and so long as it acts in good faith, its orders are not reviewable by the courts or by the SEC. The directors are also not liable to the stockholders in performing such acts. So this is what you call the business judgment rule. So meaning the Supreme Court or the courts, for that matter, will not interfere with any kinds of policy decision making or managing the business, because this is solely the discretion of the board of directors or the officers of the corporation. But there are instances when a director can be made liable, and this should be present when he willfully and knowingly he voted for and assenting to patently unlawful acts of the corporation. So there was a vote, and then the act to be voted upon is unlawful, and the director approves such unlawful act, so he would be liable for that. Secondly, when the director is gross negligent or bad faith in directing the affairs of the corporation. Thirdly, when a director acquiring any personal or pecuniary interest in conflict of duty. So this pertains to when a director acquires the business of the corporation or any kind of interest which is in conflict of his duty. Another doctrine, which is a doctrine of apparent authority. So this doctrine states that if a corporation knowingly permits one of its officers or any other agent to act within the scope of apparent authority, then it holds him out to the public possessing the power to do those acts, and has in good faith dealt with it through such agent. So be stopped from denying the agent's authority. So this means that when a corporation permits one of its officers or allowed or has authorized one of its officers or anyone for that matter, its agent. So it holds out in public that this person has been uh, given apparent authority by the corporation, and therefore the corporation can no longer retract from that uh, vestment of powers to this person. So the corporation can no longer deny the authority that he has permitted the agent to do. Okay. So in the case of People's Air Cargo and Air Warehousing Company versus Court of Appeals, way back in 1998, the court said that the apparent authority is derived not merely from practice. Its existence may be ascertained through the general manner in which the corporation holds out an officer or agent as having the power to act. In other words, the apparent authority to act in general with which it clothes him. So a corporation has given a general manner in public that this officer or agent has the power to act in behalf of the corporation. And letter B, the acquiescence in his acts of a particular nature with actual or constructive knowledge thereof, whether within or beyond the scope of his ordinary powers. It requires presentation of evidence of similar acts executed either in its favor or in favor of other parties. It is not the quantity of similar acts which establishes apparent authority, but the vesting of the corporate officer with the power to bind the corporation. So therefore, if a corporation gives or vests upon a corporate officer apparent authority, then such officer is clothed with authority. And any act that he has rendered would bind the corporation. Okay. So the corporation cannot say, hey, I cannot be made liable. It is not me acting, it is only my agent. Why? Because of this doctrine, the doctrine of apparent authority. Another doctrine is the doctrine of corporate opportunity. This is also discussed in Title 3 of this code, that if there is presented to a corporate officer or director a business opportunity, which a corporation is financially able to undertake, and from its nature is in line with the corporation's business and is of practicable advantage to the corporation, and one in which the corporation has an interest or a reasonable expectancy. So, meaning there is a business opportunity presented to the corporation, of which the corporation is financially capable, and by the line of this, it is in line with the corporation's business, and the corporation has interest or reasonable expectancy in this kind of transaction. But instead of giving it to the corporation, the director has embraced this opportunity, or as the self-interest of an officer. Yeah? So, because he is an insider, he knows the events of the transaction, because he's an officer, he's a director. So instead of bringing it to the corporation, he embraced the opportunity as his own. No? Ikuha niya yung negosyo. Siya na yung nagnegosyo. Ako rin eh. No? Therefore, the law does not permit this kind of attitude or taking advantage of the position. So, seizing the opportunity, even if he used his funds, his own funds in the venture, if he seizes the opportunity, thereby obtaining profits to the expense of the corporation, then this officer or this director, he must account for all of the profits that he has made in that venture. And he would refund the same to the corporation unless by any act or of the corporation allowed him through ratification or has ratified by a vote of the stockholders owning or representing at least 2/3 of the outstanding capital stock. So this is subject to the ratification of the stockholders. But if there is no ratification made by the stockholders, the officer or director who has embraced the opportunity must be made accountable, and all the profits must be brought to the corporation because this profit belongs actually to the corporation. Okay, so this kind of director or officer can be removed, no? So we go to the removed from the corporation. So let's go to the requisites of removal of directors from the board, or this could be the trustees, no? So first, it must take place either at the regular meeting of the board or of the stockholders, or special meeting of the stockholders or members called for the purpose. So the meeting should be called for the purpose, and the purpose should be removal of director. So it should be specified, no? Because if it's not specified as one of the agenda, then it cannot be, there would be no removal of any board member or any trustee. Second, there must be previous notice to the stockholders or members of the intention to remove the member, I mean the board, the member of the board, okay? Third, the removal must be by a vote of the stockholders representing 2/3 of the outstanding capital stock, if it is a stock corporation, or 2/3 of the members if it is a non-stock corporation. And on fourth, the director may be removed with or without cause, unless he was elected by the minority, in which case it is required that there is a cause for removal. So if the director is not was not elected by the minority, then he can remove through this, no? But if he was elected by the minority, then it is required that there should be cause for removal. Cause meaning he violated the doctrine of corporate opportunity. He violated his responsibilities as a member of the board, and so on and so forth. So if you remove a member of the board, then there would be vacancy, no? There would be a vacant seat. So how are vacancies done? So firstly, by stockholders or by members if it's non-stock. So the stockholders or members can fill out the vacancies of the board if it results from letter A, removal. Letter B, by expiration of the term. So if the term of the member of the board has expired, so stockholders or members can fill out the vacant seat. Then thirdly, letter C, the ground is other than removal or expiration of the term, where the remaining directors do not constitute a quorum. So if because there are removal of directors, then there's no longer quorum in the board. So if in that case, No, no, this is not caused by removal or expiration of the term, but in other causes like death of a director or trustee, and the remaining directors do not constitute a quorum. So in this case, the stockholders in a stock corporation or members in a non-stock may fill out the vacant seat. Or letter D, there is increase in the number of directors. So there's amendment, and the amendment has been uh, approved by the Securities and Exchange Commission that there will be an increase in the number of directors. So that's the first method of filling out the vacancies in the board through the stockholders or the members. Secondly, by the board themselves, no? If the remaining directors still constitute a quorum. So these are the cases not reserved to stockholders members. In all other cases, the election must be held no later than 45 days from the time the vacancy arose. Okay. And the third method would be by the unanimous vote of the board. So when the vacancy prevents the remaining directors from constituting a quorum, so there's no longer a quorum. Let's say there are 5 seats in the board and 3 of them has died. So there is no more quorum, only 2 remained. But there is an emergency action that is required to prevent grave, substantial, and irreparable loss or damage to the corporation. Then the vacancy may be temporarily filled from among the officers of the corporation by the unanimous vote of the remaining directors or trustees, meaning the officers, the president, the treasurer, the secretary, and any other officers set in the bylaws. No? So the requirement that there should be an emergency action required to prevent grave, substantial, or irreparable loss. And the action by the designated director, meaning the one who is now coming in as director or trustee, shall be limited only to the emergency action necessary. And the term shall cease within a reasonable time from the termination of the emergency or upon election of the replacement director or trustee, whichever comes first or earlier. But the corporation must notify the commission within 3 days from the creation of the emergency board, stating therein the reason for its creation. Okay. So it is very important that the emergency action is required to prevent grave, substantial, and irreparable loss. But if the emergency action is not required to is not required to prevent grave, substantial, irreparable loss, then there is no it's not allowed to fill in the vacancy. The remaining directors cannot fill out the vacancy. So this should be present, no? All right, section 29, the compensation of directors or trustees, Pilelas will do. In the absence of any provision on bylaws fixing their compensation, the directors or trustees shall not receive any compensation, except for reasonable per diems or per diems. So provided, however, that the stockholders representing at least a majority of the outstanding capital stock or majority of the members may grant directors or trustees with compensation and approve the amount thereof at a regular special meeting. So it should be voted by the stock holders or majority of the members, then to grant the directors or trustees must be given compensation. So how much should be the compensation? According to this provision, in no case shall the total yearly compensation of directors exceed 10% of the net income before income tax of the corporation during the preceding year. So that will be not more than 10% of the net income before income tax. So the income has not yet been deducted with income tax. Directors or trustees shall not participate in the determination of their own per diems or compensation. So this lang ang ilabot, no? Because it is self-serving. Corporations vested with public interest, like banks and SSLAs, quasi-banks, insurance pre-need, shall submit to their shareholders and the commission an annual report of the total compensation of each of their directors or trustees. So there's a reportorial requirement for corporation vested with public interest. Okay, section 31. This is about dealings of directors, trustees, or officers of a corporation, with the corporation. So if there's a contract executed between the corporation and one of its officers or one of its directors or one of its officers or their spouses and relatives within the fourth civil degree of consanguinity or affinity, is the contract valid? The answer is no. The contract is voidable. And at the option of such corporation, unless all the following conditions are present. So automatically it is voidable, meaning it is valid until annulled. No? So there's a chance that it can be voided. So unless this from A to E are present. Letter A, the presence of such director, meaning the one who is in contract with the corporation, or trustee in the board meeting in which the contract was approved, was not necessary to constitute a quorum for such meeting. So if I am the one who gets the contract, what is this contract? Contract to supply the water, mineral water of the corporation. Say the corporation has around 500 branches all over the Philippines, and I am the one who is given the contract to supply for 10 years, and I am a director. So that is a self-dealing director. So in that case, it should be proven that my presence during the meeting was not necessary to constitute the quorum. Okay, quorum is the majority. So my presence is not necessary to constitute the quorum. So if there are 5 members in the board, if there are 5 and majority is 3, so my presence is not necessary, so I should be the 4th, no? Because my presence, even if I'm absent, then there is already majority attained. So the letter B, the vote of such director or trustee was not necessary for the approval of the contract. Okay, so there are 4 present, including the director, and his vote is no longer necessary because these 3 here has already voted to approve. So his vote is not necessary. No? So the 4th is already more than the majority. Letter C, the contract is fair and reasonable under the circumstances. Okay, very clear. Letter D, in case of corporations vested with public interest, material contracts are approved by at least a majority of the independent directors voting to approve the material contract. So there should be, the independent directors are required to approve, the majority of the independent directors should be required to vote. No? Okay. So if the independent directors, the total, let's say for instance, there are 3 independent directors in the corporation, because there are total of 15, 20% of 15 is 3. It says that there should be at least 20% of independent directors. No? So if the corporation is vested with public interest, then if there are 3 independent directors. So majority of 3 is 2. No? So 2 of the independent directors has voted or approved the material contract. Letter E, in case of an officer, the contract has been previously authorized by the board of directors. So if the contract of supplying the mineral water was given to the president, who is an officer, then the requirement is that the contract has already been approved by the board of directors previously. So where any of the first 3 conditions set forth in the preceding paragraph is absent, so A, B, C are absent. In the case of a contract with a director or trustee, such contract may be ratified by the vote of stockholders representing at least 2/3 of the outstanding capital stock, or at least 2/3 of the members in a meeting called for the purpose, provided that full disclosure of the adverse interest of directors, trustees involved is made in such meeting, and the contract is fair and reasonable under the circumstances. So meaning if A, B, and C are absent, so his presence was necessary to constitute a quorum, his vote was necessary to approve the contract, and the contract is not fair and reasonable, then it can still be valid or validated by way of ratification. 2/3 of the stockholders representing outstanding capital stock, 2/3 of the outstanding capital stock, or 2/3 of its members in case of non-stock corporation. So this is the self-dealing director or officer or trustee. Okay, section 32 is about contracts between corporations with interlocking directors. So 31 is self-dealing directors. Here we have interlocking directors. So when is there an interlocking director? So if a director has a stock holding exceeding 20% in one of the corporations. So there are 2 corporations here, 2 corporations A and B. They have entered into contract, and one of in both corporations there is an interlocking director, meaning he's a director in corporation A and he's also a director in corporation B. And what is required to be interlocking is that he owns at least 20% of the outstanding capital stock in either of the corporations or in one of the corporations. But if he only holds less than 20% in both corporations, then this section 32 will not apply. So in section 32 states that except in cases of fraud and provided that the contract is fair and reasonable, then a contract between 2 or more corporations having interlocking directors shall not be invalidated on that ground alone. Okay? Meaning it shall still be valid even if except if it is fraudulent or it cannot be invalidated because the contract is fair and reasonable. To continue, provided that if the interest in the interlocking director in one corporation is substantial and the interest of the other corporation or corporations is merely nominal, then the contract shall be subject to the provisions of the preceding section insofar as the latter corporation or corporations are concerned. So if it is an interlocking director, then should be proven that the contract should be fraudulent in order to rule that it is invalid, no? But if it is not fraudulent and the contract is fair and reasonable, then it cannot be invalidated. Section 34, executive management and other special committees. So if the bylaws provide that the board may create an executive committee composed of at least 3 directors, then it may act by majority vote of all members such matters within the competence of the board as may be delegated to it in the bylaws, or by majority vote of the board except with respect to the following. Letter A, approval of any action for which shareholders' approval is also required. There will be filling of vacancies in the board. So these are the things that the executive committee or the executive management and other special committees cannot decide. No? Again, approval of any action for which shareholders' approval is also required. Filling of vacancies in the board. Letter C, amendment or repeal of bylaws or the adoption of new bylaws. Letter D, amendment or term is not amendable or repealable. Letter E, distribution of cash dividends to the shareholders. Dividends is wrong spelled. So the executive committee and executive management are not allowed to do this from A to E. So these are the exceptions. And that ends part 7 or title 3 of the Corporation Code. For any questions, comments, or suggestions, you can email me to my Gmail account, Masarin and Masarin Law, or message me to my FB account, Attorney London Mac. And we will have a quiz that will be uploaded in Moodle within 24 hours. Thank you and have a good day.